I got the idea for this feature last May when Crown prosecutors withdrew the single charge of breach of trust against Vice Admiral Mark Norman for his case which involved an alleged breach of cabinet confidence. I hadn't covered the case directly, but was fairly familiar with all the details, and I knew also that this wasn't the first time the Crown had lost a big case. This was the fourth time in just 6 years that the Crown had lost a very high-profile case. Senator Mike Duffy was acquitted of all charges. 9 Ottawa residents were found not guilty of 60 charges of rigging bids on government contracts. And Nortel's top 3 financial executives were found not guilty of cooking the books. I had followed the Duffy trial fairly closely and covered the other 2 intensively, so I resolved to revisit all these cases to answer a simple question: where did the Crown go wrong? It's impossible to know precisely in Norman's proceeding and in the case of the jury trial in alleged bid rigging because we don't have a detailed ruling. But this much seems clear. The investigators each time arrived fairly quickly at a theory of the crime which could not be proved once all the facts were known. This is not a knock just on the RCMP or Competition Bureau, which did the initial investigations. The government's lawyers also failed to insist on interviewing more witnesses, people capable of shedding more light on the cases. Again, the question is why? I concluded part of it was the sheer complexity of the cases, which prompted investigators to narrow the scope of their interviews early on. But there was a more disturbing reason as well. In developing a theory of the crime, the Crown was also informed by political pressure, in the case of Norman and Duffy, and in the other 2 cases, the pressure was institutional. The Competition Bureau had started a campaign to enforce a little understood law, and Nortel's board of directors was coping with a post-Enron era of corporate governance vigilantes. In conducting interviews for this feature, I found that some people who followed the cases from a distance believed strongly that some or all of the defendants had been guilty of something, just not something provable in court. After combing through the evidence as much as I could, I came away with a very different conclusion. These were charges which should never have been laid in the first place.